clearly I'm doing something wrong. To those of you watching this on the video, I'm really sorry. All we did is have some little background discussion about where we are in the course. You haven't missed anything important. It's interesting to look at who were the people of the first courts. John Jay, obviously, the first Supreme Court Chief Justice, co-author of the Federalist Papers, a major figure by any measure. James Wilson, second only to James Madison in his role in the creation and adoption of the Constitution. One of a half dozen people who signed both the Declaration of Independence and the U.S. Constitution, led the ratification fight in Pennsylvania, a critical state, delivered the first lectures on the U.S. Constitution anywhere at the College of Philadelphia, now the University of Pennsylvania. He delivered a famous series of lectures on the Constitution while the ratification struggle was going on. Served on the Committee of Detail, that's the committee that drafted the actual language of the Constitution, and of course, was on the Supreme Court. Samuel Chase, signer of the Declaration of Independence, leading figure among the Federalists. Right, so we're talking the first justices of the Supreme Court included people who had been directly and intimately involved in the drafting, the creation, the adoption of the Constitution, which raises an obvious question. How could they have gotten it so wrong? Because their approach to the role of the courts, judicial review, the role of the Constitution, is completely different from the one that we have and the one that we assume is right. Our generation is in the peculiar, and not only ours, is in the peculiar, the very peculiar position of asserting that we understand the Constitution's original meaning better than the people who wrote it and applied it and interpreted it in the first generation, which is a level of historiographic hubris that's kind of impressive, isn't it? All right, so that was a very provocative claim, obviously. And I want you to keep your eyes out, your ears open, for strangeness. As we go through these early cases, I'm suggesting that I'm going to be able to show you that their approach to the project is just radically different from what we talk about when we talk about the founding era. That's what I want you to keep your eyes open for. I don't want to spend a lot of time on the political background. As I say, you probably already know it. Let me point out one thing, one idea. This is debatable. You don't have to buy it, but let me lay it out anyway. You can draw a line of ideological consistency, philosophical consistency, and policy consistency, not by any means perfect, from the Federalists to the Whigs to the Republicans to the modern Democrats. And you can draw a line of consistency of ideology, policy preference, and philosophy from the Anti-Federalists to the Democratic Republicans to the Democrats to the modern Republicans. My point is not that there's a direct descendancy of these things, but there's a remarkable consistency in very, very broad strokes in the differences over what we call constitutional politics. For those of you who are interested in American conservative thought, a really excellent recent book by a guy named Ken Kirsch, with whom I went to graduate school, fine, on American conservatism, argues that the binding intellectual content across the very... One of the problems when you talk about American conservatism, just as one of the problems when you talk about American liberalism, is that it's inconsistent. It's different in different generations. It's different in different times. And the problem becomes identifying what's consistent, what holds it together. Kirsch argues that a constitutional vision, that is generally, that constitutional politics are the fundamental dividing cleavage in American political ideology across the history. All the terms move. I'm not sure that I perfectly buy it, but it's a really interesting argument. And if that's a topic that interests you, I recommend it. But in terms of constitutional politics, you can draw the kind of lineage that I've just described. And it works really quite well. Well, constitutional politics is an interesting concept. Right, you might think that the Constitution is supposed to be outside of politics. That political fights are supposed to happen within the broad confines of some shared constitutional understanding. That was presumably Madison's, for example, understanding. You might think that whether or not that happens in practice, it should be a norm. That is, we expect that it's a norm, that we think we ought to have somehow a separation between constitutionalism, that we all agree and share on, and politics, which is where we fight about policy and preferences and candidates and issues. But that's not at all how things have gone in our country. And this is, we are, I won't say unique, but unusual in this regard. Our politics, I mean just ordinary partisan, party-driven, small p politics, to a dramatic extent is driven by differences in conception of the Constitution and its proper meaning and its consequences. That's been true from the very beginning. And as I've obviously suggested, I'm going to argue that this remains true right up to the present day. Well, why do these constitutional politics change over time? Because they do. Even though I've just described a consistency, certainly the specifics change. Certainly the issues change. Certainly the positions shift back and forth. Parties, and one very notable issue, incident, very famous incident, after the 1960s, in the American South, the two parties switched roles very dramatically. Why do these, you all know this from your AP course or whatever, right? How many of you took AP history? How many of you therefore did not take, how many of you took AP, what's it called, Gov? Right. How many of you therefore did not take Intro to American Politics? Yeah, shame on you. I'm sorry. My wife's a high school teacher. I admire the hell out of high school teachers. High school teachers do real teaching. I mean, they teach 6 periods in a day on 3 different subjects. That's a much harder job, but there is no way, even a really good AP Gov class is the equivalent of at least a good college Intro to American Politics class. I have no problem with AP classes getting credit, but it bothers the hell out of me that you place out of the college version in terms of preparation. Sorry, that was an unsolicited rant. I'm prone to them. So how do these things evolve over time? One theory is parties. I've already mentioned this, but once parties exist, parties have interests of their own. Robert Michel coined the iron law of oligarchy. Any organization comes to be ruled by an oligarchic group whose interests are independent of whomever they were supposed to represent in the first place. Labor unions, political parties, corporations, it doesn't matter. Countries. There comes to be a governing group, and they have interests and concerns of their own, and that drives. He coined that theory in 1911. Second theory, people just change their minds. I'm still dwelling on this question. How is it possible that the first generation of Federalists, the people who wrote the Constitution, secured its adoption, understood it in a way, I'm going to argue, so radically different from the way we talk about it now? How could things change like that? So one answer is parties came to be, interests drove the train. Second theory, people just change their minds. James Madison is famous for this. I've been quoting Madison a lot because, of course, he's very famous. What I haven't mentioned is that a lot of scholars who study Madison think that if you just jump 10 years forward in his life, you can find him saying the opposite. And 10 years after that, sometimes switching back again. For the record, I actually don't buy that theory. I think there is a consistency to his views, but it's very much the case that if you just pick out specific arguments or quotations, if you don't like what Madison said, pick him up 10 years later, see what he's saying. So maybe we just changed our minds. Gee, that original understanding of the Constitution was nice, but time to move on. We should, instead of doing what was originally anticipated, rewrite the thing, we just changed our minds of how we thought about it. But it's the same basic idea, adaptation. Third possibility, coalitions change. Right? Maybe Madison, despite the existence of national parties, wasn't wrong about shifting factions if you think in terms of constitutional politics. Who favors a strong and empowered Congress with lots of authority over the economy? Well, from different historical periods, different interests, different people, different ideologies may take that position, and others may take the opposite. And so maybe it's just a matter of shifting coalitions, like a fixed set of variables or a fixed palette of colors and just different pictures. Fourth theory, it's simple. The party in power changes. This is all just politics. Parties have bases. Parties have constituents. Parties are formed for a purpose. The constitutional politics changes as the party in power changes. If my guy does it, it's constitutionally good. If your guy does it, it's constitutionally evil. It's just all raw politics. You could probably come up with a fifth and sixth and seventh theory. But if you think about it, it's a really interesting and complicated question. The sort of thing that people write history books about. One thing that is very clear is that these debates, the terms of these debates move. They move from an early period that we're looking at today, in which the question is, what is the political meaning of the Constitution? What did we create here? What is this national government? What is this relationship to the state government? What are the governments, plural, sorry. What is the relationship among the branches of this government? What are the scope of its power? Moves from that what did we make here approach to a legalistic constitutional interpretation approach. And that's the move to the courts. That's the point at which the courts become the key institution. Because when you stop asking, what did this do? And instead, what is its deep meaning? And instead you ask, what is its specific technical meaning? Now it makes perfectly good sense to have technical experts be in charge of answering the question, and that becomes the courts. All right, that's just all background. You got some notes here about some specific issues, a couple of elections. One thing I should mention, it's in the notes, but I didn't bother putting a lot about this. I've said this before. Let me say it again. Slavery was like a gravitational force, like an unseen planet that distorted the orbits of everything around it. And let me give you an example. Between 1800 and all the way up to the 1850s, people like John Calhoun. John Calhoun had been an ardent Federalist and a great supporter of federally funded internal improvements. That especially became true in the 1820s and 30s, when there was a depression in 1837, triggered in part by 7 different states defaulting on their railroad bonds. He said, boy, we need a federal currency, we need a federal, but not federal spending on infrastructure. Why not? Because he said once you allow the federal government to be in the business of building canals or building railroads, they would have the power to abolish slavery. Nathaniel Macon, member of Congress and a member of the Senate. I have a nice quotation from the letter here, but I won't bother looking it up right now. But he says, who does not see that a national government that has the power to spend money on building canals has the power to emancipate the slaves? So attitudes about internal improvements, federal taxing power, federal spending power, but as early as the 1820s, earlier even, but very clearly by the 1820s, are driven by the fear on the part of slave states that an empowered national government would be a threat to their peculiar institution. That's just one example of the way everything we're talking about is, stick with my own analogy, is gravitationally affected by the question of slavery. Let's actually look at the cases now. Chisholm versus Georgia, 1793. The Constitution is only 2 years old. All right, it's ratified, it goes for ratification in 1787. The process isn't finished until 1791. The Constitution in its full form is 2 years old. Listen to how, that's what we're looking for, weird these arguments sound when compared to what we think of as arguments about constitutional law. The question was, could a guy in South Carolina, actually his estate, he died, his estate, there was a debt owed to him by Georgia for, wait for it, war debts. Yep, war debts again. These were domestic. The supplier of goods to the Continental Army hadn't been paid, to the Georgia piece of the Army hadn't been paid. He sued to get his money back. He sued in federal court. Why, under Article 3, did he sue in federal court, somebody? Remember when we went through the thing and I said, read the text, because blah, blah, blah. Now I'm just making you feel bad, or trying to. Is it working? Article 3 says federal courts have jurisdiction over suits between a state and a citizen of another state. So here's a citizen of another state suing a state. Easy, right? No, says Georgia. That can't be right. Why cannot that not? Why is it the case that that cannot be right? Sovereignty. Georgia is a sovereign nation, a sovereign state. And one of the aspects of sovereignty is that you cannot be called to answer in somebody else's courts. Therefore, said Georgia, that provision of Article 3 cannot mean that we can be sued by a citizen of a state that is not Georgia. The Supreme Court ruled they were wrong, 4-1. They said, no, that's exactly what it means. Now, we'll get to Jay's opinion in particular. The text is really pretty clear. Suits between states and citizens of another state. So what's the point of this sovereignty argument? Well, Georgia wasn't really making a legal argument. They were making a political argument. It is not the nature of the United States that the individual states have ceased to be sovereign. We remain sovereign nations. And therefore, we are entitled to our sovereign prerogatives. And we are entitled to reclaim them, just like any other country that signs a treaty. Georgia was asserting the compact theory. And Wilson and Chase and Jay, three of the leading Federalists, were having nothing to do with it. And their arguments here are just a core articulation of the high Federalist theory. So this is a more detailed explication of the political understanding on the part of the people who made the Constitution as to what now some of them. Federalists disagreed with each other, just like anti-Federalists disagreed with each other. But actually, these three guys disagree with each other, even in this case. But this is a more detailed explication of what some of the key actors in the drafting and the promulgation, the adoption of the Constitution thought that it meant. We start with Wilson. The Wilson opinion is on canvas. The rest are in the book. These are all excerpts, of course. The real ones are much too long. And Wilson begins with a remarkably powerful statement. Sovereignty is not a concept we recognize, period. To the Constitution of the United States, the term sovereign is totally unknown. Think of the debates. We read the Anti-Federalists, right? And we read the sovereignty. That's a radical statement. This is a whole new theory of politics, right? The new science of politics. We have a version of government that doesn't involve sovereignty at all. To the Constitution of the United States, the term sovereign is totally unknown. There is but one place where it could have been used with propriety, but even in that place, it would not perhaps have comported with the delicacy of those who ordained and established that Constitution. They might have announced themselves the sovereign people of the United States, but serenely conscious of the fact they avoided the ostentatious declaration. Right? In the preamble, where it said, we, the people of the United States, the one place you could use the word sovereign in the Constitution, says Wilson, is it could have said, we, the sovereign people of the United States. But even that would have been indelicate. What does he mean? Here's Wilson explaining that America and Americans have discovered a deep truth about republics unknown to anyone who's gone before. It's the American exceptionalism argument. We have developed a new theory of politics. I call it the great inversion. Let a state be considered as subordinate to the people. Remember the term constituent power from an earlier lecture, the idea that fundamentally the people have the authority to establish constitutions, create governments, but all legitimacy must come back to the people. Let the state be considered as subordinate to the people. Let everything else be subordinate to the state. All right, let's imagine we're talking about France. Let's agree that France, the French state, ultimately comes from the people, but beyond that philosophical observation, let's say everything else is subordinate to the state. Traditional politics that way. Well, as the state has claimed precedence of the people, so in the same inverted course of things, the government has often claimed precedence over the state. We have it backwards. When we look at the countries of Europe making treaties, making wars, doing their thing, what do we say? We say it's the king or the queen or the government who is acting. That's the sovereign. What is the sovereign rule? The state, France, England. Who are the subjects of the state? The people. The people are at the bottom. This is backwards, says Wilson. This is exactly backwards. We understand that legitimate authority comes from the people. They're at the top. They are the most important source of authority, not the other way around. And to this perversion in the second degree, many of volumes of confusion concerning sovereignty owe their existence. Right? He's not just saying, look, we have understood this error, we don't believe in kings. He's saying anytime you use the word sovereignty, you're making this mistake. The whole anti-federalist discourse on sovereignty fails to recognize that we're doing something new here. We are not recreating France or a bunch of little Frances. By a state, I mean a complete body of free persons united together for their common benefit. Right? The state is not the geography. It's not the kingdom. It's not the realm. You could say France is what's within the borders of what's called France. You could say France is that which is ruled by the king of France. No, says Wilson, those are both wrong. France is the people whom it comprises. So what's the state then? The state is, he says, essentially a corporation. Now I have to be very careful here. Corporations in those days didn't mean what they mean nowadays. There was no such thing as a general business corporation. That arises in the 1870s. Corporations here meant things like cities, towns, and governments. You ever drive outside of Madison? You pretty quickly get into areas that say unincorporated. Instead of the Madison police, you have the sheriff's department patrolling the streets. Incorporated Madison is the city, actually there's a city of Madison and a town of Madison, both. outside defined political boundaries with authoritative charters, you're in unincorporated Wisconsin. That's what the term meant in this period. And he's describing the state, all versions of the state, as this kind of thing. It is an artificial person. It has its affairs and its interests, it has its rules, it has its rights, it has its obligations, it may acquire property distinct from that of its members, right? You can have res publica, publicly owned land. You can have property or land or goods owned by the state. It may be bound by contracts and for damages arising from breach of those contracts. Right? So the state is an artificial entity, this old school notion of corporation created by the people and authorized to act in various ways. Now, if we say that all government comes from the people, we're invoking that line we're invoking Locke, we're invoking social contract, we're invoking the Declaration of Independence. All legitimate rule comes from the consent of the governed, right? This is we call it popular sovereignty. Wilson says that's a misnomer. Well, if consent, mutual consent in the social contract theory, is what creates a commonwealth out of a group of persons, that same, and we individually are bound by that consent, states that we create must also be bound by that same consent. The only reason I believe why a free man is bound by human laws is that he binds himself. Consent. Upon the same principles upon which, upon the same principles upon which he becomes bound by laws, he becomes amenable to the courts of justice. Right? Remember, the whole question here is jurisdiction, federal court jurisdiction. He's working his way around there. He says, you join a commonwealth, you form a commonwealth, you agree to be bound by its laws. You agree to be bound by its laws, you agree to be bound by its courts. That's part of the system. Locke says the same thing. If one free man, an original sovereign, may do all this, why may not an aggregate of free men, a collection of original sovereigns, do likewise? Notice, he is absolutely not going to use the language of states forming the union. It was people who formed the union. An aggregate of free men. As a result, states cannot be above the law, because the people who created the states are not above the law, because if they were, there wouldn't be a social contract in the first place, so we wouldn't be a commonwealth. A state, like a merchant, makes a contract. A dishonest state, like a dishonest merchant, willfully refuses to discharge it. The latter is amenable to a court of justice. The dishonest merchant is amenable to the courts of justice. You can sue him. Upon general principles shall the former, when summoned to answer the fair demands of its creditors, be permitted Proteus-like to assume a new appearance and declare, I am a sovereign state. Right? First Georgia was a merchant, buying and selling things, borrowing money, purchasing on credit. Now suddenly it's something else, a sovereign state. Oh, you can't sue me for these debts that I've incurred. The states get to do that, go back and forth, become sovereign when it suits them. Of course not, he says. This is why the whole idea of state sovereignty is simply alien to the Constitution. In one sense, the term sovereign has for its correlative subject. The King of England wouldn't be a sovereign if we didn't say the people of England were his subjects, right? That's what sovereign means, the ruler. In this sense, the term can receive no application, for it has no object in the Constitution of the United States. Under that Constitution, there are citizens, but not subjects. We don't have sovereign states because we don't have subjects. Nor are the people of the United States subjects of the government of the United States. That's the inversion. That's the getting things backwards. The people are the source of all that power and that authority, and they can take it away or distribute it as they see fit. The citizens of Georgia, the people in that particular area, when they acted upon the large scale of the Union as part of the people of the United States, now notice the model he's describing. The Constitution was created by the people of the United States, acting in localized areas. That's how he envisions all this. Did not surrender the supreme or sovereign power to that state, but as the purposes of the Union retained it to themselves. As to the purposes of the Union, therefore, Georgia is not a sovereign state. So now that we've laid this rather radical, to the anti-federalist ears, and frankly to most modern jurists' ears, notion that the whole language of sovereignty is simply inappropriate in a federalism question, let's get down to cases. 2 questions, he says. 1, could the Constitution vest jurisdiction in the federal courts over a claim against the state, which was asserting itself to be sovereign? That question, what can the Constitution do, is quite different from his second question, Did the Constitution vest that jurisdiction in federal courts to hear claims against a state asserting itself to be a sovereign? That first question, what can the Constitution do? The anti-federalist position, the position that asserts that states are sovereign, doesn't just limit what the Constitution did or how it should be interpreted. If accepted, it would limit what the Constitution can do. And for Wilson, that's the fundamental problem here. There can't be a limit on what the people can do. The people are the source of authority. So first question, could the Constitution vest this jurisdiction? Excuse me, allergies. So he goes back to his great inversion theory, right? Even in almost every nation which has been denominated free, the state has assumed a supercilious preeminence. Hence the haughty notions of state independence, state sovereignty, and state supremacy. Is a toast asked? United States instead of the people of the United States is the toast given. This is not politically correct. As far as I know, this is the earliest use of the phrase politically correct anywhere in the English language. It's kind of charming. Right? But when you say, here's the United States, you're actually missing the point. You should be saying, here's the American people. It is the people, not the government which serves the state which the people established. That defines America. The people of the United States are the first personages introduced. Who are those people? They were the citizens of 13 states. The question now fairly open to our view, could the people of those states, right? This is what the Constitution could do. Could do. Among whom were those of Georgia, bind those states and Georgia among the others by the legislative, executive, and judicial power so vested. Right? If Georgia says it is impossible for Article 3 to create this jurisdiction because we are a sovereign state, what they're saying, says Wilson, is that the people lacked the power to create a constitution that would work in this way. But for a state to assert itself to be superior over the power of the people, that's the inversion. That's the fallacy of European royalty. So the answer is yes. The people could do this. The Constitution could do this. And go back to this little paragraph that I just read you. Could the people of those states, among whom were those of Georgia, bind those states by the judicial power so vested? This is the new beginning model. Wilson's vision is that with the adoption of the Constitution, it's as though everybody got into a room and started over. Everything was on the table. We could have abolished states. We could have had 2 states instead of 13, or 74 instead of 13. We could have, whatever comes out of the Constitution, according to Wilson, is an act of the people of that moment with a new beginning. That, according to the high Federalist view, is how you must understand the Constitution. And that's why nothing can be off the table, because nothing is beyond the limits of the people. And that moment was not bound by some previous agreement, right? Don't forget, the adoption of the Constitution violated the terms of the Articles of Confederation. Doesn't matter. The people have the supreme authority. We talked last time about the Article 5 and restrictions on amendment. Sure, but the people could simply abandon the Constitution and make a new one. There's no way to write a Constitution that says, by the way, please don't replace this with anything new. That doesn't, I mean, you can write it down, but it doesn't do very much. So Wilson's view is that the moment of the adoption of the Constitution was a new beginning, which the people of the United States got together as a whole, located in their geographical areas, because geography and technology, and decided, we'll give this power to the states, we'll give this power to the national government, we'll do this, right? But no entity that existed before that moment had anything to say. Because to say anything else would be the inversion. It would be to say that sovereignty resided in the state or the government or the head of government rather than in the people. Well, all right, fine. That's a nice philosophical argument about what the Constitution could do. And as we go forward, keep your eyes open right up to the present day. We still have people arguing the Constitution can't do that, which to a Federalist is a very strange argument. To an anti-Federalist, it makes perfect sense. If you think we are a confederation, a treaty of 13 separate independent nations, then of course there are limits to what that treaty power can do. Because no sovereign can give away his own sovereignty. No king can make a treaty when he stops being king. But if you buy Wilson's argument that that's not how we work, we don't have these sovereigns, we were ruled by the people, then that makes no sense. But aside from philosophy, what about what the Constitution did do? Did the Constitution as adopted, mean that federal courts get to hear cases against states who don't want to be there. Well, certainly that's true, he says. That is certainly, that is true, he says, with respect to state legislatures. How does he know? Because Article 1, Section 10. Okay, I know I gave you a hard time before, just snark, about did you read the Constitution carefully enough? This one would be hard to catch. But if you go back to Article 1, Section 10, there's a provision that says states may not impose duties, right, on trade from other states, unless doing so is absolutely necessary for purposes of inspection, like quarantine. Very relevant, of course, in the era of COVID. Very relevant discussion. And Congress may revise those statutes if it wants to. Article 1, Section 10 specifically in this particular area gives Congress the authority to override state legislatures and rewrite their laws in this area. There's another, he doesn't mention, there's another one, elections, remember? The time, place, and manner of elections. Congress may determine, contrary to the actions of the states, how those things should work. And as I mentioned to you, it was Congress that gave us our present system of congressional districts. It's not the Constitution, it was purely Congress. Well, wait a minute, says Wilson. If we have at least one, and I've just pointed out at least two, places where the Constitution explicitly says the federal government can overwrite state laws, then the general principle cannot be that states are sovereigns and therefore have sole authority over their laws, and the national government cannot intrude. That would be a contradiction. Where certain laws of the states are declared to be subject to the revision and control of the Congress, and in the footnote he cites Article 1, Section 10. I didn't bother reprinting the footnote. You don't have to take my word for it, you can look it up. It cannot surely be contended that the legislative power of the national government was meant to have no operation on the several states. See, I can't argue, right, what a true argument of state sovereignty would mean. The national government has no authority to interfere with the states in ways they don't want. That can't be right, he says. It's specifically contradicted by a couple provisions of the Constitution. Well, okay, but what about courts? We're not talking about the Congress, what about courts? The question here is, did the Constitution give federal courts the authority to hear claims against the state? And again, remember, from the compact theory perspective, from the sovereign state perspective, this would be like an English court requiring the King of France to appear to answer a lawsuit brought to him by an English citizen, which under a theory of sovereignty is impossible. So is that what happened here? Fair and conclusive deduction, then, evinces that the people of the United States did vest this court with jurisdiction over the state of Georgia. Listen carefully. It was the people of the United States, is that new beginning theory. They decided, where does jurisdiction go? Where does authority go? What's the division between federal and states? He's already said, there's no limit to what they could have done. And so based on what we've just reviewed, it's a fair deduction that this is what they did do. It is confirmed beyond all doubt by the direct and explicit declaration of the Constitution itself. The judicial power of the United States shall extend to controversies between two states. Right? I mentioned earlier the provision about suits between states and citizens of another state. But another thing in Article 3 says that the federal courts have jurisdiction over suits between two states. Well, wait a minute. Suppose it were, pick any two states, Georgia and South Carolina. Supposing the two states were suing each other. This happens all the time. Water rights, for example. There's a case in the Supreme Court right now which Mississippi is asserting that Tennessee is draining its aquifer by well digging that violates its water rights. Water rights is one of the areas, borders another one. You know the Great Lakes Compact? You ever heard of this? Wisconsin, Ohio, Illinois, and I forget who else, it's 5 states, are all involved in a deal about coastlines and water use and things like that. Those questions go to the courts, to federal courts under Article 3. Well, wait a minute. If Georgia sues South Carolina, that means South Carolina can be dragged into court. If South Carolina is a sovereign, we just went through this. If South Carolina is a sovereign, no other sovereign can force it to appear in its courts. It's like a foreign country. Like the national government is a foreign country. The national courts are foreign courts. But we know that's not right, because Article 3, aside from the provision I mentioned before, says there's jurisdiction over suits between two states. One of those states is suing, and one of those states is being sued. And the one that's being sued is being subjected to the jurisdiction of a federal court without having chosen to do so? Can the most consummate degree of professional ingenuity devise a mode by which this controversy between two states can be brought before a court of law and neither of those states be a defendant? So that's it. That's his argument. He makes three arguments, right? The purpose of the Constitution, a new beginning, the assertion of constituent power, or if you prefer, the assertion of sole and unique sovereignty in the people as a whole, the structure of the Constitution, well, look, this is how it works with the legislatures, and this is how it works with the courts, and the text. There's a specific provision that would make no sense if George's argument were accepted. Jay agrees with the outcome, but Jay's argument is, well, it's a little different. Well, it's definitely somewhat different. Let's take a look. Jay just starts sort of in the middle of Wilson's argument. He just says, look, Georgia consented. Now, it's a really interesting way to put the argument because that suggests that maybe he is accepting the idea of Georgia as a sovereign state. Maybe he's saying it was a treaty, but this was part of the treaty. Your government, your ruling legislature, which is the sovereign, agreed under the terms of the treaty. You can withdraw from the treaty, but you agreed to this jurisdiction. That's what it sounds like at first. Let us proceed to inquire whether Georgia has not, by being a party to the national compact. So Georgia's a party. Does he mean the state government of Georgia? The state of Georgia? Or the people of Georgia? That's the conundrum Wilson has posed. Georgia, by being a party to the national compact, consented to be suable by individual citizens of another state. This inquiry naturally leads our attention, one, to the design of the Constitution, two, to the letter and express declaration in it. Notice those two questions. The design of the Constitution is a political question. What have we built here? What are these institutions? What's the design? What's the system? What are the principles? The letter and express text, that's a legal question. And we're starting to see the tension between thinking of the Constitution as a political declaration of principles and creation of a system, and the Constitution as a legal declaration subject to the kind of arguments you make about contracts, or wills, or deeds that are conveyances of property. First, he says, let's look at the design of the Constitution. And he says, let us now turn to the Constitution. The ordinary rules for construction will easily decide whether those words are to be understood in that limited sense. That is, he talks about the need for national courts to hear international suits and interstate suits, and then says, why do you need national courts? Because no one's going to trust the local courts. The local courts will be preferential to the party that's from their jurisdiction, to get hometowned, right? So he talks about all that stuff and says, okay, let's apply these principles. This extension of power is remedial. That is, the grant of power to the federal courts is remedial. It's to solve a problem or cure an injury or undo an injustice. It is therefore, because it is to settle controversies. It is therefore to be construed liberally. He's citing a legal principle of construction. This is in the context of his supposedly political discussion about the structure of the Constitution, but he's citing a common law judge's rule. Where a provision is remedial, it should be construed liberally. That's not in the Constitution. That wasn't in the debates about the Constitution. This is a pure importation from ordinary law, this particular principle of how to read statutes, being brought into the question of constitutional adjudication. So Jay is treating this much more legalistically than Wilson does. And he's importing this lawyer's practice or judge's practice into the discussion. But then he goes on and says, it is politic wise and good that not only the controversies in which state is plaintiff, but also those, does everybody understand the difference between state as plaintiff and state as defendant here? Right? If the state's the plaintiff, it goes to federal court and files the suit. It was its idea. It acted first. If the state's the defendant, it's being dragged in. Hey, come to court and defend yourself. Should be settled. Both cases, therefore, are within the reason of the remedy. Right? He announces this legal principle, but then he quickly jumps to this political principle. Sort of a general notion of justice. Then he goes to the text, and he rejects the idea that we should read the text in a way that contradicts its words. I mean, you'd have to say that it was like, this is what I call the drafting error theory. You would have to claim that the writers of the Constitution, two of whom are in this discussion, right? Just somehow completely misstated what they intended to do. Just got the words wrong. If the Constitution really meant to extend those powers only to controversies, in which the state might be the plaintiff, it is inconceivable that it should have attempted to convey that meaning in words not only so incompetent, but also repugnant, a direct contradiction. Furthermore, and he comes back to this political idea, what is wise? What is good constitutional design? It would be wise and useful, he says, to read this in the way that gives jurisdiction to the federal courts. The extension of the judiciary power of the United States to such controversies appears to me to be wise because it is honest and because it is useful. It is honest because it provided for doing justice without respect of persons by securing individual citizens as well as states in their respective rights. It is useful because it is honest because it leaves not even the most obscure and friendless citizen without means of obtaining justice from a neighboring state. What did Brutus say? Brutus said courts will be called upon by this Constitution to do justice and equity. And this will give them a mandate to interpret the spirit of the Constitution as well as merely its text. Sure enough, Jay is trying to do both. He's trying to do both ways. He says, look, the text is very clear, but also this is consistent with the ideals of justice and the spirit of the Constitution. Iredell dissents, but not because he necessarily disagrees that Georgia should be subject to suit. Iredell, among the Federalists, is the lone strong voice, and we'll see this again, for a strict legalism. Iredell doesn't want to hear any discussions about philosophy or politics or justice or sovereignty. Iredell says, look, this is a legal question about a legal document. We got to answer it in a strictly legal way. And therefore, from a strictly legal perspective, we should be textualists and minimalists. We should just ask what are the words, and we should read them narrowly and strictly, to do no more than is absolutely necessary. I think every word in the Constitution may have its full effect without involving this consequence. A. So A, you can read the Constitution without reaching this conclusion. I'm not sure how. What we just heard. I am sure how. What Iredell is getting at is this. Iredell is saying you could read the statement suits between states and citizens of another state, or states between two states. And you could say, you know what, there's an implied condition. It's not written, but it's implied with their consent. You could argue that as sovereign states retain the authority to decline to consent in a particular case to go to court. It's a possible way to read the text. Nothing in the text, says Iredell, requires that we adopt Wilson's theory of constituent power and the people as the source of authority and American exceptionalism and new beginnings. All of that wonderful political philosophy, none of that's necessarily required by the text, and therefore we shouldn't assume it. And nothing but express words or an insurmountable implication, neither of which I consider can be found in this case, would authorize the deduction of so high a power. If you want to grant a power to Congress which is in any way controversial or is far-reaching, it better be absolutely explicit in the text. So Iredell, among the Federalists, really is unique in his strict legalistic and strict textualist approach. Wilson is the opposite extreme. Jay is kind of in between. 1796. This is one of my favorite cases, even though most people never ever read it. And I think you'll see why in a minute. The question, so the stand. There's a little timeline in the notes, and you're going to need it. There was a guy in Virginia who owes money to British merchants. The debt is incurred in 1774. I don't know what month. I don't know if it was before or after the Articles of Association. It doesn't matter. But this is before Declaration of Independence. This is back when this is definitely part of Britain, right? So you got a guy in Virginia, merchant of some type. He owes money to a merchant or banker in England. 1774, that same year, Congress starts discussing independence. We're going to boycott England. Remember all that stuff? 1776 is, of course, the Declaration of Independence, at the end of which there is a statement that each state is now a sovereign nation and entitled to all the rights and prerogatives of other sovereign nations. I know this is review, but trust me, we're going to need it. The next year, in 1777, Virginia adopts a law. And the law Virginia adopts says no one from England may use our courts to collect a debt. If you claim someone from Virginia owes you money, come talk to the state government. We'll decide whether or not to enforce your claim. Right? Our courts will not recognize legal claims of any kind from people from England. Everybody get it? What's the obvious likely outcome here? Obviously, Virginia is likely to say no. They're going to protect their merchants and their citizens against English creditors. That's the point of the law. Ware, a lawyer on behalf of an estate, gives the owed money to the Virginia State Treasury in 1780, and sure enough, the Treasury turns around and says to the English creditor, "Too bad for you, we're keeping it. Go pound sand. Your claim has no validity in our courts." 1781, the Articles of Confederation are adopted. 1782, Treaty of Paris, although it's finalized in 1783. And one of the things there was the treaty ending the American Revolution. And one of the things the Treaty of Paris says is that American courts will enforce claims by English creditors. So now we have a contradiction. The 1777 Virginia law is directly contradicted by the terms of the Treaty of Paris. I know this is a lot of detail, but can you see why you need all this right? So our question is, what is the relative status of the 1777 law and the Treaty of Paris in 1796, at which time, of course, we're under the Constitution? The decision is 5-0, and Virginia loses. Now, remember that in Chisholm, I pointed particularly to Wilson, but also to Jay, as espousing the new beginning theory. The adoption of the Constitution was a brand new beginning. Everything that went before was null and void. It's as though everybody got into a room and decided, okay, what should we do? That is also Chase's theory in this case, even more strongly. Chase was so staunch, not to say strident, a Federalist, that he got himself impeached once the Jeffersonian Anti-Federalists took over Congress. Historians agree it was absolutely purely political. All right. So we have to go through, he says, a whole series of claims to figure this out. So one claim brought by the English merchant is that the law in 1777 that Virginia adopted was invalid because Virginia was still part of Great Britain. Or alternatively, because by that time, the power to settle debts had been given to Congress as part of the war-making power. I know this is getting really technical. Is everybody still with me? These technical questions turn out to involve very, very big issues indeed, especially this earlier era. But this is the nature of our system. Even big questions arise in the context of specific disputes. We'll say some more about this, but ours is the only constitutional court system, I won't say in the world, but certainly in Western democracies, in which this is true, which constitutional questions can only be answered if they arise naturally in the course of a private legal dispute, which gives our constitutional law a weird mosaic effect. Little bits are clarified here and there, but never the whole picture, because it's only what came up in a particular controversy between particular parties. It's one reason we have so many unanswered questions all the time. That's a theme we'll come back to. All right, so is that true? A, says Chase, the English merchant is wrong, so Virginia wins on this point, to say that Virginia in 1777 lacked the authority to make this law. Why? Because in 1777, Virginia was a sovereign nation, a sovereign state. I hold it as unquestionable that the legislature of Virginia, established, as I've stated, by the authority of the people, note that Federalist reliance on the people, was forever thereafter invested with the supreme and sovereign power of the state and with the authority to make any laws in their discretion. As long as that version of the state of Virginia exists, it has this sovereign power. The people gave it that power. How do we know? Read the last paragraph of the Declaration of Independence. The legislative power of every nation can only be restrained by its own constitution. Right? Only the people of Georgia, Virginia, whatever state we're talking about, only the people of Virginia, through their constitution, can impose restraints on a sovereign government. There's no question, but the Act of Virginia Legislature in 1777 was within the authority granted to them. All right, so Virginia wins on that question. What about the merchant's other argument? By 1777, the power to make laws of this kind had been given to the national government as part of the war-making power. Nope, that's not right. Virginia wins this argument as well. And to understand why, you have to ask, what were the powers of Congress between 1774 and 1781? It's interesting he says 1774. He's recognizing that underground illicit Congress as a Congress of the United States. Right? But until the Articles of Confederation, in this period between the beginning of the Revolution, this is the period in which Virginia made this law. What were the powers that the states had given to Congress? The powers of Congress in this period originated from necessity and arose out of and were limited by events, or in other words, they were revolutionary in their very nature. This is a revolutionary government. It did what it had to. It was absolutely indispensably necessary that Congress should possess the power of conducting the war against Great Britain. And therefore, I do not hesitate to say that Congress did rightfully possess such power. The authority to make war implies the power to make peace. I entertain this general idea. The several states retained all internal sovereignty, and Congress properly possessed the great rights of external sovereignty. So what was the situation up to 1781? A strict delineation. There was a national Congress that had foreign affairs power. That's all that it had. It's the treaty model. And each of the states, the constituent states that formed this treaty, retained full sovereignty over their internal affairs. Again, Virginia wins as to that argument. Furthermore, in this prior period, let us recognize there was no written constitution. There was not even an Articles of Confederation. In the absence of a written constitution, how can we know what are the legitimate powers of a government? The answer is whatever powers they actually exercised. This actually goes back to the English idea of parliamentary sovereignty. English writers had said for a long time, and continue to say right into the 20th century, there can be no restriction on Parliament because Parliament speaks for the people. Therefore, there can be no limitation on the authority of Parliament. Therefore, how do we know if Parliament has done something illegitimate? If the people don't revolt, it was okay. Basically, it comes down to that, right? It's like the lock thing. If the government should act in a way that destroys the Commonwealth, the people have a right to replace it. That's the English parliamentary supremacy argument, and Chase is saying that applied just as well before 1781. The absence of this idea of this innovation, a written constitution, whatever is done and is not virulently objected to, or perhaps violently, how do you register objection? This is a great question. But whatever is done and accepted must be okay. Before the Confederation, I see but one safe rule, namely that all the powers actually exercised by Congress were rightfully exercised. They were so authorized by the people, they were represented by an express or implied grant, and that all powers exercised by the state convention or state legislatures was also rightfully exercised. So, up to 1781, no question, Virginia was a sovereign state. Virginia had the authority to make this law. There's no indication that the people of Virginia objected violently to this law. All good. Virginia wins. What about the Treaty of Paris? What's the effect of the Treaty of Paris? The question may then be stated thus: whether the fourth article, the piece of the treaty, nullifies the law of Virginia passed in 1777, etc. So now we're looking at the period from 1781, or 1782, the treaty, to 1787. That is the period under the Articles of Confederation. What was going on in that situation? Well, during the period of the Articles of Confederation, says Wilson, it seems to me that treaties made by Congress, according to the Confederation, were superior to the laws of the states, because the Confederation made them obligatory on all the states. The Articles of Confederation says treaties, all states are bound by the treaties. So Chase says, look, you can make a really good argument that under the Articles of Confederation, that law became invalid because of the treaty. But of course, that's not what he really cares about. What he really cares about is the Constitution. And here's where we get the point where he argues, and you can see now, by the way, I think why I went through that chronology earlier, 1774, 1776, setting up this case and what comes after. Chase argues in proper high Federalist fashion that the adoption of the Constitution was a new beginning. Everything else is swept away. If doubts could exist before the establishment of the present national government, they must be entirely removed by the 6th article of the Constitution, which is the Supremacy Clause. If a law of a state contrary to a treaty is not void, but voidable only by a repeal, what's the alternative? Right? What does the Supremacy Clause mean? One argument, this is an argument made by Virginia. The Supremacy Clause only means that if we, the state of Virginia, choose to accept the treaty or the federal law or the piece of the federal constitution in question, then we will undertake to rewrite our laws accordingly. No, said Wilson, that's not what it means. Says Chase, excuse me. They agree. Says Chase, that's not what it means. What it means is any law contrary to the U.S. Constitution or federal law or a treaty is simply void. It is unconstitutional, hence void. If a law of a state contrary to a treaty is not void, but voidable only by a repeal or nullification by a state legislature, this certain consequence follows that the will of a small part of the United States may control or defeat the will of the whole. Right? What's the point of a treaty with Britain? In which Britain says, okay, but our creditors have to be able to collect their debts. If one state can say, yeah, but not in our state, at that point the treaty is broken, and the whole desire of the United States to end the war with Britain is screwed up because one state didn't agree to that one provision. That can't be right. Don't forget, even under the Articles, blah, 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 English. Sorry. Yeah, I know. You try doing this with a mask on for this. Even under the Articles of Confederation, the agreement by 9 states was sufficient to take all 13 of them into a war. Wilson argues that by implication that means they also have the authority to come out of a war. No, Chase again. Damn it, I keep doing that. They really do agree a lot. Chase argues that means that, I mean, he doesn't put it quite this way specifically, but he says the power to make war is the power to make peace. So if 9 states could start a war, 9 states could end a war. Now here we are under the Constitution. The U.S. government, through Congress, can start a war. We know the U.S. government can end a war. That has to bind the states. Otherwise, that power is pointless. And so he says, 4 things are apparent on a view of the Supremacy Clause. 1, it is retrospective. It trumps everything that came before. The adoption of the Constitution wipes out everything that there was before and puts everything open to question under the Constitution. Why? Because otherwise you have the paradoxical and ridiculous situation in which things done under the Articles of Confederation that violate the Constitution nonetheless still have to be treated as valid. And that defeats the entire purpose of a Constitution. It defeats the idea of popular sovereignty and constituent power. It defeats the idea that the people, by remaking their Constitution, had the authority to adjust state and federal powers as they saw fit. It defeats the whole New Beginning argument. Chase is coming back to that political philosophy stuff in a very core way. To deny the Chase-Wilson high federalist theory implies that the Constitution, remember the question, what can it do? Lacked the power to undo or evoke or contradict things done earlier. And that can't be right, because if that were right, it isn't the Constitution. So 1, it is retrospective. 2, the constitutional laws of any of the states that shall be found contrary to that treaty are prostrated before the treaty. Supremacy. They are lesser. 3, consequently, the Treaty of 1783 has a superior power to the legislature of any state. Now listen to this phrase, because no legislature of any state has any kind of power over the Constitution, which was its creator. The states were recreated at the moment of the adoption of the Constitution. Virginia after 1787 is not the same as Virginia before 1787. It's that New Beginning model. All the people got together and said, should we have states? Yeah, let's have states. Should we have the same ones we have now? Yeah, let's keep the ones we have now. What powers should they have? Oh, let's do this and this and this. It's not the same Virginia it was before. It is a creature of the Constitution. 4th, that is the declared duty of state judges to determine any constitutional laws of the state made under the authority of the United States null and void. National or federal judges are bound by duty and oath to the same conduct. Notice, by the way, there's one historical debate people have in the early years of the Republic, the founding of the Constitution, right, was the original understanding that there should be strong judicial review, the ability of courts to strike down laws on the grounds that they are unconstitutional. For Chase, the answer is absolutely yes. It is the declared duty to determine any constitutional laws of any state, right? That includes the state constitution, which emphasizes the point of the New Beginning, right? You all see why? The people of the state are part of the national people, therefore the state constitution itself has to be rewritten and re-understood in terms of the new constitution that is being adopted. That would make no sense if this were a sovereign state. That it is the declared duty of state to determine any constitution or laws of any state contrary to the treaty made under the authority of the United States null and void. It is the duty of judges to declare these laws void. So for Chase, the Supremacy Clause means several things. I'm repeating myself, but right? It's that New Beginning theory. This is not the same thing it was before. The old state constitution isn't even operative anymore. if it contradicts this new one, this new federal constitution. And it is the affirmative obligation of both state and federal judge to declare laws null and void that contradict this new constitution. And remember, it's only 1796. We're only 5 years in. The people on the bench were there. Was the high federalist view that I'm describing universally accepted? Of course not. We read anti-federalist writings, remember? We know there were contrary arguments. Were these views of Chase and Wilson in particular universally accepted among all federalists? No. Jay and Iredell, for starters. Jay has at least a very different tone, and Iredell disagrees outright. It's a myth that even within the Federalists there was a single unified vision. But it is striking, I think. I hope I've succeeded in showing you that the version of constitutional adjudication undertaken by our first Supreme Courts, by members of those courts who were active participants in the drafting and promulgation of the Constitution, looks nothing at all like the way we think about questions of constitutional law nowadays. And their vision of federal-state relations is wildly more nationalistic and wildly more radical than anything any modern court would accept, which raises the fascinating conundrum. How does it happen that we today have a better understanding of the meaning of the Constitution than the people who wrote it and promulgated it and got it adopted and were the first judges to apply it? It's kind of an interesting question. We will continue on this same vein next time. It is not until the lecture after next one that we'll finally see a glimmer of what looks familiar to us as modern constitutional legal reasoning, and that's Marbury versus Madison. But first, we had a couple more cases to go to explore a little more the implications and the approaches of the first Federalist courts, the Jay and Ellsworth courts. See you then.